Hey, this is attorney Elizabeth Potts Weinstein, and today we're going to be talking about how to find and protect the intellectual property assets of your business. No matter what kind of business you have some kind of intellectual property. Even if you don't kind of think of your business as having creative works or inventions or anything like that, no matter what kind of business it is, it's going to have something that can be protected by trademark law, copyright law, trade secret law, or patents. And the secret is going through your business, kind of doing an audit of your business to find these assets so you can strategically and intentionally protect them to increase the value of your business. So why would you want to do that? First is just to protect your investment. Whatever you've created, whatever you've been building in your business, you want to make sure that no one can take it away from you. No one can open up something the exact same and steal all your clients or customers. Just the protection of your brand, protection of your investment into the business is important. Second, by building up assets in your business, it's something that someday you could sell. It could be something that you pitch to investors to invest in your business. It could be that you sell this entire business, this entire brand. You may not have any plans to sell your business someday, but you might want to. So it's good to protect those assets now and build them now so you have more options in the future. The third reason is if you actually want to license those assets to somebody else to use or other companies to use. This may also not be something on your radar yet, but if you create a brand, if you have copyrighted works, inventions, all those different kind of things, you can license other companies to use them or produce them in areas, maybe part of the country, part of the world, different markets that you don't want to go into, but this way you can still make money on those other markets. So let's get into the 4 different types of intellectual property. Primarily, we're talking about trademarks, copyrights, trade secrets, and patents. Those are the 4 different areas. Now, every business isn't going to have all of these, especially the patents. That tends to be the one that some businesses just don't have. It doesn't apply to most of them. However, you probably have something you can protect under trademark law, and you definitely have things you can protect under copyright law, and you probably also have trade secrets in your business. So let's get into that. First, let's talk about trademarks. Any kind of word, phrase, logo, symbol that you use to brand your business in the conjunction with the sale of a product or a service can be protected under trademark law. If it meets other requirements, obviously, everything's a bit more complicated. Think of it from the perspective of your consumers, of the customers, clients, whoever buys your stuff. How would they perceive you as the source of that product or service? What branding do they associate with that? That's the thing that may be protectable under trademark law. Now you get some, in the United States, you get some protections under state law as soon as you start using that branding in conjunction with the sale of a product or service in that state, in that area. But it won't protect you everywhere in the United States because it's state by state. So to get protection everywhere in the United States, you have to register your trademark with the United States Patent and Trademark Office. Now, that's just for the United States. If you want protection in Canada, in Australia, in France, in China, every country is going to have their own system for protecting trademarks, and you will need to register in any of those places where you also want that protection, and then hire a lawyer there and pay those fees and all that kind of stuff. It's just something to be aware of because it is common for someone to get a registered trademark in the United States and not realize that it doesn't apply to people buying their products or services or someone setting up a business with the exact same name in a different country. One thing you can do right now, even if you haven't registered the trademark on that name, brand, phrase, logo, is you can start using that little TM symbol as part of that branding. You see this all over the place if you start noticing it with big companies that sometimes they use the R with a circle around it. That's a registered trademark. But sometimes it's just a TM. The TM, you don't actually have to file anything with anybody to start using. It just means that you're kind of putting the world on notice that you perceive that word, phrase, tagline, logo, whatever, as a trademark for you. The thing is, your average person doesn't know there's anything different. And it's helpful in making your brand look more valuable, and it's helpful in keeping other people from stealing your stuff. So it's something I recommend you look at today for your business. Are there words, phrases, logos, symbols, taglines that you're using in conjunction with your sales of products or services to identify your brand that you can use the TM symbol on right now? And then later, if you apply for a registered trademark and it's granted, you just switch it over to the R. The second intellectual property that we're going to talk about are copyrighted works. Now, a lot of people associate copyright with something that's artistic or creative. So if you're a graphic designer, if you're a writer, if you're a photographer, you may already be thinking about copyrights. But a lot of other business owners don't think about it at all because they don't feel like they have a business that has this kind of creative, artistic aspect. But most likely, I don't know any business that hasn't created something that is protected under copyright law. If you are writing marketing copy for your website, if you're creating a flyer, if you're taking photographs of your products, anything that is a artistic work that is put into a tangible format has protection under copyright law in the United States. This creative work could be just a photo of your products, okay? If creative work could be just the about page that you wrote to put on your website. Anything that is written, a photograph, a graphic design, any of that stuff is protected under copyright law. Now you have some protection in copyright law as soon as you put it into a tangible format. Tangible doesn't mean physical, it means something that isn't, giving a speech isn't tangible, but the recording of the speech is tangible. It can be electronic. Thinking about copyright law, what it tends to come up with a lot for businesses is, one, do you need to register copyrights on things? And you can't sue somebody for infringing your copyright unless you've registered it. You also get more protections if you register the copyright within 3 months of creating it. So look into, for your most valuable things that you've created, whether or not you register the copyright. It's not very expensive. You do it at copyright.gov. The big thing that comes up for a lot of business owners is when you have someone else create something for you. If you're a business owner and you have someone create a logo for you, you're a business owner and you have someone writing articles for your website, then you want to make sure that you have the rights over the stuff that was created. Either they assign that to you or they are licensing it to you. And that needs to be in writing, okay? There needs to be some kind of contract or license or something in writing where you either get assigned the trademark to you, which means you own it, or that you are licensed to use it and maybe even have an exclusive license to use it. A lot of people think that just because you pay someone to create something for you that you own it. That is not true. Work for hire, the licensing assignment, that all has to be done in writing. So anytime you have someone create something for you, there needs to be some kind of written agreement that says what you're actually getting, not just the physical thing you're getting, the file with the thing that was created, but what are you getting from an intellectual property rights standpoint? Do you own it? Do you just have a license for it? If you have someone else create something for you, it still can be registered with the Copyright Office. How you do that depends on if they're assigning it to you, if it's work for hire, if you are just getting a license. So, that really depends on the circumstances, but either way, it can be registered with the Copyright Office. The third item are trade secrets. So a trade secret is something that is your proprietary thing, method, process, thing you've created that derives value for your business because it is secret. So one of the classic examples is the recipe for Coca-Cola. The myth surrounding the recipe for Coca-Cola is that only 2 people in the world know the recipe for Coca-Cola, and they're never in the same place at the same time, and they're never on the same plane. I don't know if that's actually true, but the idea is if Coca-Cola had patented the recipe for Coca-Cola, the patent would have expired many, many decades ago, and anybody would be able to make Coca-Cola as a generic Coca-Cola. And instead of doing that, what they did is they had it be secret. I don't know how you logistically have a recipe for something that's mass-produced be secret, but that's what the myth is. And so since they have it be secret, that means, and they protect it by having people sign NDAs, by going through all this different secrecy of nobody knowing it, etc., they can keep it secret. So if someone went in and just stole the recipe for Coca-Cola, they could file a lawsuit against them. They could get an injunction against them from them revealing it online. They can get damages if it was revealed online. So in your business, you may not have a recipe for Coca-Cola kind of thing, but you probably have something in your business that you keep secret, that you have proprietary. It could be information that you've collected on your clients and customers where, you make evaluations about clients, about how much money that they are going to be able to spend on this and how you're going to pitch them, and things that are in the back end the client never sees and nobody else sees. It could be processes they use for you to do your work, the way you produce your products. It could be recipes that you use to make things. It could be processes that you use to deliver your services. That tends to be the kinds of stuff that are trade secrets for really small businesses. Also, computer code, things that don't get revealed to the public. Now, to protect that, you don't have to file that with anyone. Exactly, in a way, it's the exact opposite. You have to keep it secret. So you have to have a non-disclosure agreement signed by anybody who sees the stuff. And whether it's your employees, you'd have them sign some kind of NDA or confidentiality agreement. If you have vendors, if you have an independent contractor, anybody who's seeing this stuff has to sign an NDA. Otherwise, they have no duty to keep it secret and you lose that value. You also need to look at practical ways to keep things secret. So things having password protection, things not being on some kind of publicly accessible computer. Hopefully none of your computers are publicly accessible, because that's always going to be a bad idea from a hacking and cybersecurity perspective. But the idea is you want to make sure there's processes, so the only people who get that information are people who need to know. If you have a company that has 10 employees, everybody doesn't need access to that proprietary information. There's going to be some people who definitely do, and then there's going to be all kinds of people who do have a completely different kind of job, and they have no need to have access to that customer information, or they have no need to have access to that product. So they need to be restricted from access. You want everything to be on a need-to-know basis. And then also have a process that if someone leaves the company, whether they quit or get fired or laid off or whatever, they no longer have access. And you remind them that they signed an NDA and they are on a duty to keep this secret. One of the other big things that can happen with a lot of small businesses, or actually even large businesses do that, is if you have employees or staff who use their own phones for their work, they may have synced all the customer databases and stuff like that on their phone. And if this is their personal phone, let's say, then they're going to walk out the door with all that stuff on their phone. So there's ways to deal with that. One is to provide them a business phone, and they're supposed to use that for business. They can't put any of their personal stuff on the business phone. They can't do the business stuff on their personal phone. It keeps everything separate, and then they hand that back in on their last day. You also can use certain kinds of apps and things like that that you can reject access to once they're separated from service, from working for you. So there are ways to manage that, but I found that that's one of the biggest subtle issues that happens for small businesses is the information that is on your employee or other staff members' laptop or phone. That's their personal item that they're going to take with them after they leave. You want to make sure that they also don't take your trade secrets with them too. The fourth intellectual property are patents. Patents protect inventions that have some kind of purpose. They have to be novel. They have to be useful. A lot of businesses actually aren't going to have something that's patentable. So this is the one that's applicable to the least number of businesses. It can be something that is a product, a physical product. It can be something that is the process for making a product. Maybe the product isn't something that's patentable, but the process you use is something that's novel. And also, there are design patents. Design patents cover the design of a product, so kind of the way it looks. Designs of a product can be actually protected under multiple things. It could be patents, it could sometimes be trademarks, it could be copyrights. There are a lot of intellectual properties that can be under multiple categories. There are logos, could be copyright law and trademark law. So there's some overlap between all these different areas to be aware of. Another aspect that may be patentable are methods of doing business that typically is around software and doing business online. So if you've created an app, you have some kind of software company, I suggest that you talk to a patent attorney to see if anything in your business is patentable, because that is a very It's not something that I could easily explain in a YouTube video, and it really depends on the exact circumstances. And you don't really want to ask questions about that online. It's something you want to discuss in private with a patent attorney. So what I suggest that you do for your business is you go through your business and go through these 4 different areas and just brainstorm. What do you already have? Do you have logo? Do you have some kind of brand name? What stuff have you created for your website, for your marketing, for internal documents? Anything that's possibly protected under patent law as some kind of novel invention. Going through your business, every kind of business has some kind of intellectual property that they have that can be protected. Making a list of that and prioritize what you want to do. Some of these things like trade secrets, protecting a trade secret has very minimal cost except for getting the NDA together and kind of the logistics of protecting it, making it secret. Some of them, like trademarks or even more patents, cost money to get that registration. Copyrights are very inexpensive, but trademarks cost more and then patents cost a lot more. And for something as complicated as trademarks or patents, especially applying for a patent, I highly recommend you hire an attorney to do that because it is complicated and also weird, non-intuitive. But you want to start with just looking through your entire business, everything you've already created, to see where those assets already exist so you can protect what you already have. And then as you go forward, you keep in mind intellectual property so you can see it as you create it in the future. Again, this is attorney Elizabeth Potts Weinstein. If you found this video helpful, give it a thumbs up. Subscribe for more content like this. Sign up for the membership program if you'd like to help the channel to be able to create more videos like this for you. And leave a comment below if you have any questions about your intellectual property you'd like me to answer, point you in the right direction. Thanks a lot for watching. Bye.